I'm sure you guys remember those alternate electors from Georgia who were slated to potentially be faithless electors that are now being prosecuted by the Fulton County DA. Yeah, they're going to court again. According to the Washington Examiner, 11 Republicans who signed certificates as alternate 2020 Georgia electors asked a judge to disqualify Fulton County District Attorney Fani Willis from her investigation into efforts by former President Donald Trump and his allies to overturn the state's elections results. That's not what's happening here. Alternate electors are not there to quote unquote overturn the state's election results. The group wrote in a court filing Tuesday that they are inextricably intertwined with State Senator Burt Jones, one of the so called fake electors, whom Fulton County Superior Court Judge Robert McBurney recently ruled cannot be investigated by Willis due to a conflict of interest after she hosted a fundraiser for Jones's Democratic opponent. Yes, of course. Again, nothing to see here, right? A special grand jury convened by Willis, a Democrat, is investigating whether Trump and his people illegally attempted to influence the 2020 election in Georgia. During a fallout from the 2020 election, allies of Trump encouraged the state legislators to put forth an alternate slate of electors while they challenged the election results in several states narrowly won by Joe Biden, including Georgia. Efforts to challenge the results were roundly rejected in courts across the country. Yes, with multiple affidavits attached and people who were willing to go to court, and now the same people that were willing to step up and be alternate electors, which I'll explain here in a moment, are now being prosecuted by the courts. Again, because this is tied to Trump, yeah, these people are regular everyday people being charged. Straight from ballotpedia.org, federal elections. Article 2, Section 1 of the United States Constitution provides that the President of the United States is elected by the Electoral College via majority vote in a single winner contest. Of the 50 states, all but two award their presidential electors to the presidential candidate who wins the popular vote in the state. Maine and Nebraska each award two of their electors to the candidate who wins a plurality of the statewide vote. The remaining electors are allocated to the winners of the plurality vote in the state's congressional districts. Article 1, Section 4 of the United States Constitution grants the states the authority to determine the rules by which they elect their United States senators and representatives, unless the United States Congress acts to change those rules. Throughout the years, it appears that almost every state has completely adhered to a national or at least a majority popular vote system. You need to get into your state constitutions and speak to your state legislators to understand why that's a problem. Now that most states adhere to a majority popular vote, this is how Georgia's role in the Electoral College has changed. The Electoral College is the process we use to elect the U.S. president, established in the U.S. Constitution. Its purpose is to spread the power to elect the president across all 50 states. It was designed to ensure that more populous states didn't overpower the smaller states when choosing the nation's leader, because in reality, the nation's leader is a leader of the states. Therefore, all states would need equal representation under the executive branch of the federal constitution. When you cast a vote for a presidential candidate, you're not actually voting for the president. You're voting for a group of people called electors. Electors are the individuals who form the Electoral College. Each elector represents one electoral vote. A total of 538 electors form the Electoral College. Each state has its own number of electors, which equals its number of senators, two for each state, and representatives based on the state's population in Congress. Georgia has two senators and 14 representatives. So we have 16 electors. States with more people are represented by more electoral votes and vice versa. In Georgia and 47 other states and the District of Columbia, electors vote according to who wins the popular vote. So if the Republican candidate wins the popular vote, that party's electors vote for their candidate to become president of the United States. If the Democrats candidate wins our state's popular vote on election day, our 16 electors nominated by the Democratic Party will be sent to the Electoral College to elect their candidate. It's also worth noting more often than not, the candidate who wins the popular vote also wins the Electoral College vote due to the way that the states now count their electoral votes in state. But it is still possible for a candidate to win via electoral votes alone. This has happened 5 times: 1876, 1888, 2000, and 2016. Now that we have some background on the Electoral College, what is the law on faithless electors? The electors who will ultimately cast votes for the president and vice president are chosen in advance of the general election by political parties. Electors pledge to vote for the candidate from their party if that candidate wins the most votes in the state. Faithless electors are electors who ultimately vote for someone other than for whom they pledged. Neither the U.S. Constitution nor the federal status address the concept of a quote unquote faithless elector. This issue is reserved to the states. And as a matter of fact, there was a very recent Supreme Court ruling about this. To my great surprise, this opinion was actually delivered July 6th, 2020. This case is Chifolo versus Washington. Justice Kagan ended up delivering the opinion of the Supreme Court in this case. And let me just read to you some highlighted sections. The provision they approved about presidential electors, she is referring to the Article 2, Clause 2, says each state shall appoint in such a manner as the legislator thereof may direct a number of electors equal to the whole number of senators and representatives to which state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed as an elector. The next clause, but don't get attached, it will soon be superseded, set out the procedures the electors were to follow in casting their votes. In brief, each member of the college would cast votes for two candidates in the presidential field. The candidate with the greatest number of votes, assuming he had a majority, would become president. The runner up would become vice president. If no one had a majority, the House of Representatives would take over and decide the winner. And of course, we all know that that is not the case any longer because of the rise of political parties. And she continues on. That plan failed to anticipate the rise of political parties and soon proved unworkable. Was it unworkable, or did we corrupt the system? I digress. The nation's first contested presidential election occurred in 1796 after George Washington's retirement. John Adams came in first among the candidates and Thomas Jefferson second. That meant the leader of the era's two warring political parties, the Federalists and the Republicans, became president and vice president, respectively. Further in, Kagan goes on. As all states now do, Washington requires a political party's fielding presidential candidates to nominate a slate of electors. See Washington Rev Code 29A 3201. On election day, the state gives voters a ballot listing only the candidates themselves. See 29A.56.3202. When the vote comes in, Washington moves towards appointing the electors chosen by the party whose candidate won in the statewide count. But before the appointment can go into effect, each elector must execute a pledge agreeing to mark her ballots for the presidential and vice presidential candidate for the party nominating her. 29A56.084. And the elector must comply with that pledge or else face a sanction. At the time relevant here, the punishment was a civil fine up to $1,000. So the electors are now being told by state law how they are going to vote. And apparently, this doesn't violate any laws because it is in line with the Electoral College. Here's how they're going to rectify it. Not all states attempt to bind electors' votes through the appointment process. Some states simply impose a legal duty that has no connection to elector appointment. See ante at 5. For example, New Mexico imposes a legal duty on its electors. All presidential electors shall cast their ballots in the Electoral College for the candidates of the political party which nominated them as presidential electors. And then it goes on to cite New Mexico statute, and any presidential elector who casts his ballot in violation of this duty is guilty of a fourth degree felony. California has a similar system. It imposes a legal duty on electors to vote for the nominated candidates of political party they represent if those candidates are alive. Then it imposes a punishment on every person charged with the performance of any duty under any law of this state regarding elections who willfully neglects or refuses to perform it. These laws penalize electors for their faithless votes, but they do not attempt to regulate the votes of the electors through the appointment process. In fact, these laws have nothing to do with the elector appointment, and that's exactly how they're circumventing the Constitution. They are not necessarily interfering with the way that the states are electing or appointing their electoral college members, but the states then can dictate how that electoral college will vote. The court recognizes the distinction between these two types of laws: laws enforcing appointment conditions and laws that regulate electors outside of the appointment process. See ante at 5, recognizing that some states merely impose a duty by law, but it claims that this is merely a small semantic difference. Concluding the opinion, the federal government and the states thus face different default roles, where the Constitution is silent about the exercise of a particular power. The federal government lacks that power and the states enjoy it. ID at 848. See also United States versus Comstock, 560 U.S. 126, 159, 2010. Thomas J. Dissenting. This allocation of power is apparent in the structure of our Constitution. The federal government is acknowledged by all to be one of enumerated powers. McCulloch v. Maryland, 4 Wheat, 316, 405, 1819. The powers delegated by the Constitution to the federal government are few and defined, while those that belong to the states remain numerous and indefinite. The Federalist 45, page 292. So basically, if your state doesn't have a specific law against faithless electors, then it's not really a crime to be a faithless elector. And if you are in violation of some type of code, it's usually a slap on the wrist fine for going against the prescribed doctrine for the electors. This is why, again, it is so important that you read through your state constitution and know what your local and state election laws are. Because the Department of Justice is not going to stop, and interference is going to continue. This article is from The Guardian. Florida Republicans targeted Black voters, Justice Department says in filing. The department told a federal appellate court that a lower court had correctly evaluated claims of racial discrimination when it came to Florida's new law. Florida's law was pretty similar to Georgia's law. In March, U.S. District Judge Mark Walker blocked new restrictions on the availability of absentee ballot drop boxes, regulations for third-party voter registration groups, and a ban on providing food and water to people standing in line to vote. Again, very, very similar to the Georgia voting laws. The U.S. Court of Appeals for the 11th Circuit paused that ruling earlier this year while it considers an appeal from Florida officials. In their opinion, the Justice Department's allegation of racial discrimination is significant because the agency carefully chooses when to get involved in voting dispute litigations filed by private plaintiffs, which again brings us back to the affidavits that were signed and sworn to by how many private citizens in regards to the discrepancies seen in the 2020 elections, but I digress. After going largely quiet under Donald Trump, the Justice Department's voting section has filed challenges to voting laws in Georgia, Texas, and Arizona, in addition to filing several briefs in other voting disputes. Meanwhile, in Alabama, CJ Pearson receives John Lewis Youth Leadership Award. Friday, October 15th, 2021, Montgomery, Alabama, Secretary of State John H. Merrill has awarded Mr. CJ Pearson with the National Association of Secretary of State's John Lewis Youth Leadership Award. This award was created in February 2021 as a way for the NASS members to recognize a gifted, civic minded young person in their state each year. By the way, this is CJ Pearson. And this is exactly why they are on a tirade to destroy not only your understanding of the Electoral College, the actual significance of implementing an Electoral College from Jump Street, why they had to have this dismantled with the rise of parties as this became an issue moving forward. And you guys really need to jump on the bandwagon in restoring your state's electors and their ability to elect the best representative for the states, not necessarily who won the popularity contest in America. But that's all I have for you guys today. I will catch you on the next one.